from the perspective of a lawyer bringing cases to the European Court of Human Rights, a couple of preliminary points which are on the notes. First of all, the application form. The application form used to be in a format that allowed the advocate to fully argue the case before it was submitted to the European Court of Human Rights. There was no limit on the amount of submissions that can be put in. The application form now is electronic, very, very limited. You have to make the case in about 3 pages. True, you can add 20 pages of supplementary material, but if you can't make the case in 3 pages, if you go over the electronic form limit, your application will be rejected. Of course, this has got practical reasons lying behind it. As probably everybody here knows, the European Court of Human Rights has got a backlog of nearly 100,000 cases. So they are desperate to rule out cases. They're desperate to diminish the load on the registrars that do the first sift of applications to them. But anybody thinking of bringing a case to the European Court of Human Rights has got to grapple with the idea that no matter how complicated the facts or the law, you've got to be able to reduce it into 3 pages. Second point I wanted to make by way of procedure is in relation to the applicant. The European Court of Human Rights entertains applications, of course, from any citizen in a Council of Europe state, all 47 of them. But they also entertain applications from all organisations, which means from a trade union perspective, the applicant can be an individual worker or an official of a trade union, and also the trade union itself. And that brings me to the 4th bullet point on my notes here. The state has got an obligation not merely not to interfere or restrict a trade union and other rights, of course, but also to establish a system of law which prevents others, such as employers, interfering with fundamental human rights. And that was established, has been established in a number of cases, but in the trade union field, the case of Wilson and Palmer against the United Kingdom is one that I'm very proud of, where we established the right of a trade union to be heard on behalf of its members, a right which was enforceable both by the workers, the trade union members, and by their trade union. I've skipped over the 3rd point, but I'll mention it now. Very, very important point from the perspective of trade unions considering bringing applications to the European Court of Human Rights, and that is that Article 35(2)(b) of the European Convention precludes the court entertaining a case which has been subject to a decision by another procedure of international investigation, and that includes decisions of the ILO Committee of Freedom of Association. So any trade union thinking of bringing a case to the European Court of Human Rights has got to think very, very carefully about whether it wishes to make a prior complaint to the ILO Committee of Freedom of Association or to the European Committee on Social Rights, which is the supervisory body for the European Social Charter. Well, now let's talk about trade union rights under Article 11 of the Convention. I've set out Article 11 at in the notes at the end of this. Article 11, so far as trade unions are concerned, is important for protecting freedom of association, including the right to form and to join a trade union for the protection of his or her interests. And those words at the end are absolutely crucial. It's the trade union right, or the right to be a trade union member, for the protection of the workers' interests. Now, this phrase has been developed through the jurisprudence of the European Court of Human Rights, and the most important case is, without any shadow of a doubt, the case of Demir and Beykara against Turkey, which was decided 7 years ago. And in that case, it was held that the right to collective bargaining, the right to collectively bargain, is an essential element of Article 11, an essential element of Article 11. The court in that case, in fact, identified some other essential elements: the right to form a trade union, the right of a trade union to seek to persuade the employer to hear what it has to say on behalf of members, the Wilson and Palmer case, and it could have mentioned some other ones, such as the right to draw up and enforce union constitutions, such as the case that I was involved in, ASLEF in the United Kingdom, where the court upheld the right of a trade union to determine that it would not allow fascists to join its ranks. So these are essential elements of Article 11, and it gives you an idea of the breadth of trade union rights protected by the European Court under Article 11. Demir and Beykara was also important because of the process by which it reached that conclusion. And part of its reasoning rested upon international law. It took into account the conventions of the International Labour Organization, in particular the two fundamental conventions, Convention 87, which protects the right to organize, and Convention 98, which protects the right to collectively bargain. It also took into account the provisions of the European Social Charter of 1961, revised in 1996. It took into account also the Charter of Fundamental Rights of the European Union. And it said that all this international law could not be ignored by the European Court and influence the way in which it was going to interpret those few words in Article 11 which protect trade union rights. But in doing so, of course, it gave to us as lawyers a marked importance and significance to ILO conventions and decisions of ILO bodies and decisions of the European Committee on Social Rights, which previously we might not have thought that that jurisprudence had. Always regarded, often regarded in the academic textbooks as soft law, as opposed to hard law enforceable by the European Court of Human Rights or other national courts or the Court of Justice of the European Union. That it's soft law still, in the sense that you cannot enforce directly a decision of the ILO Committee on Freedom of Association, for example. But it's not as soft as it was after the decision in Demir and Beykara, because those principles now may be taken into account by the European Court of Human Rights and therefore directly enforced against a member state. Demir and Beykara, of course, was on collective bargaining. It's curious that over the last 7 years since the decision in Demir and Beykara, there have actually been no further decisions on collective bargaining itself in the European Court of Human Rights. And that is curious because, as I said at the beginning, I don't think it's controversial. There has been a war on a sector-wide collective bargaining right across Europe, and applications have been brought and upheld in other international fora, such as the decision of the high-level committee which investigated the situation in Greece a couple of years ago and found the termination of sector-wide collective agreements to be in breach of ILO Convention 98, but none in the European Court of Human Rights, and that is odd. There are decisions of national courts which are very troubling on the subject of collective bargaining, and which, to my mind, are the sort of cases that might well be brought to the European Court of Human rights. I'm going to mention two of them. I think one of them got into my notes, but not the other one. The one that got into my notes is a case decided by the Swedish Labour Court on the 25th of November of last year, called Fondship. And the facts in that case were that a ship owned by a Finnish company but flagged in, I can't remember which country it was flagged in, but somewhere in the West Indies, Panama or somewhere like that, was crewed by Russian officers and Polish crew. And when it docked in Sweden, the Swedish transport unions, backed by the International Transport Workers Federation, required the owner to enter into a collective agreement which would have paid ITF rates of pay to the seafarers. This happened on two separate occasions, in fact. The Swedish Labour Court held that not only was the industrial action unlawful under Swedish law, but the collective agreement which they had forced the owner to enter into was null and void. Now, that seems to me to be absolutely on a par with the facts in Demir and Beikara, which involved the annulment by a state court of a collective agreement between public service workers, local authority public service workers, and the local authority. So it does seem to me that the decisions of that kind might possibly be challengeable in the European Court of Human Rights. And there was another decision just a week before that in the Polish Constitutional Court, in which a law which forbade civil servants entering into a collective agreement was held to be valid by the Polish Constitutional Court, which decided that that was not in breach of the of Article 11 of the Convention. I just have the text of it here, but I've lost it. No matter. That was the principle in the case. They held that these civil servants had the right to make representations to their state employer, and that was sufficient to satisfy the requirements of Article 11, even though the legislation denied them the right to bargain collectively. That decision, for those who need to know, was the 17th of November 2015, decision K5/15. I've got an unofficial English translation of the main points in that judgment. I don't know whether it's more widely available. But once again, that seems to me to be a national decision which seems to fall foul of Demir and Beikara and Article 11 of the Convention. Well, let's turn to the right to strike. There have been a whole series of cases on the right to strike in the European Court of Human Rights. I think we've only got time this morning just to mention the last three of them. And we'll start with a case that I heroically lost in the European Court of Human Rights 2 years ago, called National Union of Railway Transport and Maritime Workers against the United Kingdom. I will just take a moment to explain the facts of that case and the reasoning of the European Court. We brought the case on two grounds. One was that in a strike involving the workers who supplied electrical power to London Underground, a very small number of workers, under UK law, we were meant to inform the employer of the number of workers, their workplaces, and the categories in which they work. That's a requirement of UK law. And we failed accurately to describe the categories in which these workers worked. And for that reason, an English court granted an injunction to prevent the rail union calling those workers out on strike for higher pay. What happened then was that the union, because it was only 36 workers, then obtained the exact, precise job descriptions of those workers and reballoted the workers, as is necessary under UK law, and called the strike and won a wage rise. But it was 2 months later. And in those 2 months, the union had to pay the costs of the employer for obtaining the injunction. And those costs were £79,216, which comes to, let's say, over 100,000 euros. That point went to the European, that was the first point that was decided by the European Court of Human Rights. They held that that application was manifestly inadmissible on the grounds that the union had succeeded ultimately in holding its strike and complying with the obligations on it. The European Court didn't mention the fact that the union had to pay £80,000 of costs, or the fact that the workers were kept out of their wage rise for 2 months, or the fact that the union was forced to delay taking the industrial action which it had decided upon. All of which is, to my mind, completely objectionable. But the most objectionable point about it is that the argument that this was inadmissible, manifestly inadmissible, was a point which was never raised by the UK government or by the court itself, and it was a point on which the union never had an opportunity to put in an answer. And I'll come back to the significance of that in a moment. The other aspect of the case was that there'd been a company which worked on the renewal of the railway, and this company had hived off part of its workings with heavy machinery to a smaller company. And the smaller company, of course, took the workers under the Transfer of Undertakings regulations, under the Transfer of Undertakings Directive, on the same terms and conditions that they'd previously been employed. But that only subsisted for 2 years. After 2 years, the new employer, the small employer, decided to cut wages. So RMT called on those workers to take strike action and went through all the necessary UK formalities. And the strike took place, but the employer stood firm and the terms were cut. The union wanted to call out on strike all its members who were employed by the big company, which had hived off to the smaller company. And if they'd been able to do that, that would have stopped maintenance work on the railway completely for a short period of time and would have brought additional pressure on the small employer. But under UK law, there is an absolute total prohibition on all forms of so-called secondary industrial action. So it was not possible to do it. So that was the nature of the complaint by RMT to the European Court of Human Rights. And the European Court of Human Rights found that the ban on secondary action was permissible. It fell within the margin of appreciation, the margin of discretion, which is permitted to member states. True, it accepted that a ban on secondary action was at the extreme limit of the range of restrictions placed by European states, Council of Europe states, on secondary action. True, it accepted that both the ILO and the European Committee on Social Rights had condemned UK legislation banning secondary action and said that secondary action should be permissible. But nevertheless, the court held that ban fell within the margin of appreciation of the state. Indeed, they went further than that and said that there should be a wide margin of appreciation in relation to social, economic or industrial policy, which is an extraordinary proposition, it seems to me. Now, when one reads that case as a lawyer, it's very difficult to think that the conclusion reached is actually justified by the legal reasoning which purports to support it. And one has to wonder why the European Court of Human Rights made such a decision. And I've got no doubt that that decision, I don't hesitate to say so, that decision was a political decision. And it was made because our government, the UK government, was threatening at the time and is still threatening to terminate its arrangements with the European Court of Human Rights and the European Convention. And the members of the European Court of Human Rights thought that if a decision condemning Britain's ban on secondary action was published in Britain, the result was that the UK government would use that as an argument to extract itself from the European Convention. And the consequences of that are too terrifying to contemplate. I mean, the idea of Britain leaving the European Union is bad, but the idea of Britain leaving the European Convention is absolutely terrifying, because there can be no doubt that Russia and Turkey and other serial offenders in the European Court of Human Rights would follow suit. And what then of other international institutions such as the ILO or indeed even the United Nations? So this is a very chastening case, and heroic defeat it may be, but it really makes the trade union lawyer think long and hard about bringing cases to the European Court of Human Rights, because the precedents in favour of the union's arguments there, to my mind, were overwhelming. Well, enough about my cases. There have been two other cases on the right to strike in the European Court, which we can deal with very quickly. One is called Veniamin Tymoshenko and Ukraine last year, quickly followed by Hrvatsky Syndicate and Croatia, both of which upheld the right to strike and took it for granted that the right to strike was protected by Article 11, the only question being whether a restriction on the right to strike could be justified under Article 11(2), which requires proof of necessity in a democratic society. And I'm going to speak just a moment about that, but first just mention the purposes of the right to strike. Article 11 speaks of the protection of the workers' interests, which is a wide phrase, and if Article 11 protects the right to strike, it must be because the strike is for the protection of the workers' interests, and that doesn't restrict those interests to the interests which can be furthered by collective bargaining. And I've mentioned just in the notes 3 cases against Turkey, which indeed involved strikes which were not for the purpose of collective bargaining, although they were related to the economic interests of the workers concerned. So just a word about Article 11(2) and necessary in a democratic society. You just remind yourself of the words of Article 11(2), which are that no restrictions shall be placed on the exercise of these rights other than such as are prescribed by law and are necessary in a democratic society in the interests of various things, national security and so forth, or for the protection of the rights and freedoms of others. And then there's permissible restrictions on the military and the police and the administration of the state. Now, necessary in a democratic society is a very high threshold for a state to overcome in order to justify any restriction on the right to strike or the right to collective bargaining. And I've put in the notes some quotations there. It must fulfill a pressing social need. It doesn't have the flexibility of expressions such as useful or desirable, and exceptions to the rule of freedom of association are to be construed strictly. Only convincing and compelling reasons can justify restrictions on that freedom. In the RMT case, the issue of proportionality was raised by the government as a justification for the ban on secondary action, and the justification was that secondary action could spread far and fast beyond the original dispute, and that, in the minds of the judges of the European Court of Human Rights, justified the imposition of the ban on secondary action. That's even though the secondary action proposed in the actual case would not have spread far and fast. And I just mentioned one other case, which is not a new one, called Chassagne and France, which is a case from 2000, which makes the point that where you've got a conflict of rights protected by the European Convention, then the balance of proportionality is a delicate one for the European Court. So the exercise of the right to strike, let us say, by the workers on the one hand has got to be balanced against some right on the part of someone else, perhaps to health services or something of that kind, protected by the European Convention, or discrimination or something of that kind, the right to life. That's a delicate balance. But the Chassagne case is important because it says that where the right to be balanced is not one specifically protected by the European Court, then only where there is an indisputable imperative can interference with the enjoyment of a convention right be justified. An indisputable imperative where the right protected by the convention is not to be weighed against another right protected by the convention. And that is quite important in strike cases, because although, of course, every strike by workers is to be weighed against the damage caused to the employer, that damage is inevitable by the very nature of a strike. No strike takes place that doesn't injure the employer in some way. So the fact of an inevitable injury caused by a strike is not sufficient to exclude the right to strike of itself. Otherwise, there'd be no right to strike ever, exercisable by workers or trade unions. So the rights or interests that the employer must rely on, or some third party, have got to be beyond the normal damage. And there are examples in the European Court of Human Rights. One was the offshore workers of Norway against Norway in, I think it was 2002, where a strike in the offshore oil industry threatened to cause damage to the Norwegian economy of €1/3 billion euros a week. And the restriction on that strike, and it's requiring it to be resolved by binding arbitration, was justified by the European Court of Human Rights, saying that the damage was out of all proportion to the exercise of the right to strike. But in a normal case, that will not be so. Now, I wanted to conclude by mentioning the fact that the European Court often has regard to decisions of non-European bodies, not just international law bodies like the ILO, but also to national courts in other jurisdictions. And one of the most important cases for labour lawyers in the last 2 years, probably the last decade, maybe the last century, is a pair of cases decided by the Canadian Supreme Court at the beginning of last year. And one of them I've taken a long extract from. This is Saskatchewan Federation of Labour and Saskatchewan. I'm going to leave you to read that to yourselves, of course, but I will just highlight one paragraph, and that's paragraph 54. Can I just read that with you? The right to strike, this is the majority decision, this judgment, by the way, delivered by the Chief Justice of Canada. The right to strike is essential to realising these values and objectives. So those are the values and objectives enshrined in the Section 2D of the Canadian Charter of Fundamental Rights, which is part of the Canadian Constitution. Right to strike is essential to realising these values and objectives through a collective bargaining process, because it permits workers to withdraw their labour in concert when collective bargaining reaches an impasse. Through a strike, workers come together to participate directly in the process of determining their wages, working conditions, and the rules that will govern their working lives. The ability to strike thereby allows workers, through collective action, to refuse to work under the imposed terms and conditions. This collective action at the moment of impasse is an affirmation of the dignity and autonomy of employees in their working lives. I don't think that there is a better judicial or indeed academic analysis of the function of the right to strike in furtherance of collective bargaining than that. And it seems to me that lawyers should be well aware of this judgment and use it, as I have done, certainly in national courts as well as international courts as well. Well, that leaves a little bit of time for discussion, so thank you very much for listening.